History as it happens, July 20th, 2023. Clarence Thomas and the 14th Amendment.
Neither slavery nor Jim Crow defeated us. We recognize, as Dr. Martin Luther King Jr. declared decades ago, that the magnificent words of the Constitution and the Declaration of Independence were a promissory note to which every American was to fall heir. The history of our nation is our shared struggle to live up to that promise. It is a slow, arduous battle, but we have yet to fail.
In his concurring opinion in the ruling striking down affirmative action in college admissions, Justice Thomas argued this race-conscious policy was unconstitutional because the 14th Amendment bars all forms of racial discrimination. In other words, it's colorblind. Thomas even said the term freedmen, as in the formerly enslaved black people of the Reconstruction era, was a race-neutral category. Is this history or something else? That's next with Eric Foner as we report History as It Happens, a podcast from the Washington Times. I'm Martin DeCaro.
I don't want to get into a long debate about what we call originalism. He's the number one originalist on the court now, or maybe Alito also. You know, when you get to Reconstruction, originalism, there's a lot of problems with how it's utilized, particularly the notion that there is a single meaning in things like the 14th Amendment, the 15th Amendment, the civil rights legislation. This is ridiculous. At a time of crisis, at a time when people's views were changing radically, they held one view in 1865 about black suffrage. The next year they changed their mind. You cannot freeze the history at one moment in time.
After a speech at Notre Dame University a couple years ago, Justice Clarence Thomas was asked, what's the biggest public misperception about how the Supreme Court functions? He said it's the idea that the justices are handing down rulings to simply suit their policy preferences.
I think the media makes it sound as though you are just always going right to your personal preference. So if they think you're anti-abortion or something personally, they think that that's the way you always will come out. They think you're for this or for that. They think you've become like a politician. And I think that's a problem I think you're gonna jeopardize any faith in the legal institutions.
Well, today, Thomas's critics say his opinions, as well as those of the court's conservative majority, are designed to bring about conservative policies. It's not about constitutional scruples or originalist doctrine. They have a right-wing agenda, the critics say. And they'll point to Thomas's concurring opinion in the case concerning affirmative action. He interpreted the original meaning of the term freedmen, who are supposed to be cared for by the Freedmen's Bureau established after the Civil War, as race-neutral. Throughout his many decades on the bench, Thomas has argued the 14th Amendment, which was drafted to protect the reforms of the Civil Rights Act of 1866, is also colorblind in that it bans any kind of race-conscious policy. Now, this version of history is, of course, demonstrably false, as we will discuss with the eminent historian of the Reconstruction era, Eric Foner of Columbia University, in a moment. But it must have been music to Thomas's ears when the plaintiff's attorney in the affirmative action case stated in oral arguments that the term freedmen, as well as the slate of post-Civil War legislation and amendments, were not meant to benefit people based on their race.
Everyone knows that the impetus for the 14th Amendment was to constitutionalize the Civil Rights Act of 1866. The Civil Rights Act of 1866 is a series of bans on racial discrimination. It's a series of colorblind measures and requirements. And then one of the earliest cases this court had before it went off the rails in Plessy was a case called Strouder, where the court immediately recognized that the purpose of this amendment was to eliminate racial classifications, no matter whether they benefited whites or blacks, because racial classifications themselves impose harms. That's the affirmative evidence. Now, I know that the evidence, the pushback is the post-ratification history, but the post-ratification of the history of the 14th Amendment is not the best evidence because we know there was massive resistance to the original meaning of the text of the 14th Amendment, but it also doesn't prove anything. Every measure that's cited in Harvard's brief was a remedial measure. It was in response to the end of slavery and the position that black Americans found themselves in. Harvard does not cite a remedial measure for what it's doing today. Those same measures that it cites would not be constitutional today because because they would no longer serve a remedial purpose, and not a shred of evidence that anyone back then used race to achieve the educational benefits of diversity.
Now, I don't really have an opinion on whether affirmative action in college admissions is a good or bad policy, but I do care when nonsense history is endorsed by a Supreme Court justice. Yes, we'd all, I hope, like to live in a colorblind society, but the congressional acts and constitutional amendments of the Reconstruction era were not drafted, debated, and ratified without respect to race. Just the opposite. Their purpose was to remedy racism against black people, as Justice Ketanji Brown Jackson said during oral arguments in a voting rights case a couple years ago.
There was a concern that the Civil Rights Act wouldn't have a constitutional foundation. That's when the 14th Amendment came into play. It was drafted to give a foundational, a constitutional foundation for a piece of legislation that was designed to make people who had less opportunity and less rights equal to white citizens.
The 14th Amendment is a prohibition on discriminatory state action. It is not an obligation to engage in affirmative discrimination in favor of some groups vis-a-vis others.
No, but as the record shows that the reason why the 14th Amendment was enacted was to give a constitutional foundation for that kind of effort, for the Civil Rights Act of 1866, which was doing what the Section 2 is doing here.
All of this points to a bigger matter, one that reflects the political and legal conflicts that define the American past. What kind of country do we want to have? Freedom for whom? Liberty for whom? The 14th Amendment is not history. It's current events. It was central to the Dobbs case that overturned Roe v. Wade, a woman's right to an abortion. It even came up during the showdown over the debt ceiling because of its relatively obscure Section 4, whether the president can invoke the amendment to prevent the United States from defaulting on its debt obligations. Now, Clarence Thomas has made it clear in his writings over the past 3 decades that the Constitution does not protect an expansive view of personal rights. He abhors the concept of substantive due process, calls it a fiction. Now, again, his critics would say he's only an originalist when it suits him. But isn't that the history of the courts? It's always been a political body whose rulings are judged by the people and politicians, not only on the basis of their adherence to doctrine, but rather whether those rulings suit my preferred policies, or, speaking for myself here, adhere to a liberal vision of personal liberty and equality. Thomas takes a more narrow view of the 14th Amendment's equal protection, due process, and privileges and immunities clauses. Eric Foner, it is an honor to have you back on the podcast.
Thank you very much. I'm happy to be here.
And I have to say you have me beat because your work, your scholarship, was cited 10 times in total in the justices' opinions in the affirmative action case.
Yeah, well, just to interrupt you for a second, that is true, and it was very gratifying. Unfortunately, the negative side is all of the citations except one were in dissenting opinions. So the 6-person majority has not yet been convinced by me, apparently. Well,
yes, Clarence Thomas cited a couple of sentences from your book, The Second Founding, which I believe came out in 2019.
Yeah.
Yeah, I was going to say I was cited 0 times, so I've got some work to do to catch up to you. But he cites your work about how Mississippi was enacting black codes after the Civil War.
Yes, Justice Thomas cited my book vis-a-vis the Mississippi Black Code, which was enacted in 1865 by the government, the all-white government that had been created by Andrew Johnson. And what he likes to cite about that is that it banned, as well as limiting other aspects of black life, it banned African Americans from owning guns. And this fits into, it's not about this case, it's about previous cases, really, where he argued that gun control is inherently racist because black people have always been barred from owning guns, or generally speaking in American history. So he's enlisting me surreptitiously in his campaign for Second Amendment rights, so to speak.
Yeah, his critics have pointed out that he doesn't apply the same consistency when he discusses the Second Amendment to these other issues involving race, where he then says, well, it's race neutral in these other situations.
Yeah, you're right. That's a good point. I don't want to get into a long debate about what we call originalism. He's the number one originalist on the court now, or maybe Alito also. You know, when you get to Reconstruction, originalism There's a lot of problems with how it's utilized, particularly the notion that there is a single meaning in things like the 14th Amendment, the 15th Amendment, the civil rights legislation. This is ridiculous at a time of crisis, at a time when people's views were changing radically. They held one view in 1865 about black suffrage. The next year they changed their mind. You cannot freeze the history at one moment in time because it's such a dynamic period of Reconstruction. So, I'm just not persuaded at all that originalism is the best way to understand what the people at that time were attempting to accomplish.
And as some have pointed out, Clarence Thomas is not an originalist because the original meaning of the 14th Amendment wasn't race neutral, as he has argued in this affirmative action case. It was very much about remedying discrimination against blacks, right?
Yeah, absolutely. That's completely right. Although I'd have to say the 14th Amendment particularly has many purposes. I call it's an effort at regime change. They're trying to change all sorts of things at once to make this, instead of being a pro-slavery regime, now the United States would be a country where people's basic rights were guaranteed by the federal government. And that would apply to black people, but it would apply to a lot of other people too. But the notion that they didn't consider race when they were drafting the 14th Amendment and ratifying the 14th Amendment, one of the things that bothers me a lot about how this is used by conservatives like Justice Thomas is that you never get a black voice in the historical discussion. There were no African Americans in Congress when the 14th Amendment was ratified. And so you can't go to the congressional debates and say, well, here's what they meant before. But black people had a lot of opinions about what freedom was and what rights they should have. But that never gets into the debate about the original meaning of the 14th Amendment. I think that's a giant oversight in terms of the history of the period.
Now, I mean no disrespect to the justice, but it is inexplicable, if he's actually familiar with your work and the history here, how he could conclude the term freedmen, and then by extension the 14th Amendment, were race neutral, especially if he considers himself an originalist. What was the original meaning of freedmen?
That was black people. I mean, one of the things that a historian has to learn how to do is to distinguish between the typical and the atypical. And here you get a case. Yeah, of course, that people talked about freedmen, not about blacks in a modern sense, but these things were used interchangeably. They were synonymous in the discourse of that time. Nobody referred to white people as freedmen. When the Civil Rights Act of 1866 was being debated and passed in Congress, President Johnson vetoed it, and he said, this is more than we do for white people. Charles Sumner, the senator from Massachusetts, said, well, white people have never been in slavery. So they're using race and slavery interchangeably there. And that's how it was. His argument that because the word race is not in the Freedmen's Bureau bill, that somehow it was race neutral. When you set up an agency to deal with the problem of the transition from slavery to freedom, it cannot be race neutral. It's impossible. So I think that was one of the weaker parts of Justice Thomas's history lesson in his concurring opinion.
Yeah, I mean, they mentioned the Bureau of Refugees, Freedmen, and Abandoned Lands. And the argument there is, well, the refugees were mostly white, but there are still separate categories there. There are refugees and freedmen.
Yeah, exactly. But people at the time would have been very mystified by this debate. If they had heard us now, they'd say, well, obviously, we're talking about freedmen. Freedmen is black people. 3.9 million slaves had become free as a result of the Civil War. How many of them were white? Not a lot. In fact, none of them were. But if you can elevate it, that's only one point. The larger point is people were not thinking in modern terms about race-neutral policies. That was not a concept. That was not a language that was employed. The term, our Constitution is colorblind, comes from John Marshall Harlan in 1896 in his dissent in Plessy versus Ferguson. But that was not the ruling of the Supreme Court. That was from a dissent about racial segregation mandated by state governments. You've got two purposes at hand. One is to protect the basic rights of the former slaves, the freedmen, and two, to create a general set of principles for the country. So it's the 14th Amendment starts with birthright citizenship. Anybody born in the United States is a citizen. Well, that doesn't depend on race. That's basically overturning the Dred Scott decision, which said no black person can be a citizen. But that's a general principle for the entire society. So you might say that principle is race neutral. But when you get to other things, the Civil Rights Acts, the Freedmen's Bureau Bill, black suffrage, the debates over that, these are not race neutral concepts in Reconstruction. So you have to keep in mind which aspect of the 14th Amendment you're talking about. The general principles for everybody and what citizenship means, and the effort to protect the basic rights of the former slaves. That's a racial policy.
And none of this means that affirmative action is the right or wrong policy today to diversify student bodies in colleges. I don't really have an opinion on that. I know that everyone's supposed to have an opinion about everything these days. I've
got an opinion anyway.
Yeah, I know the arguments on both sides. I'm not here to debate affirmative action, but something that Annette Gordon-Reed brought up to me in a podcast a couple of weeks ago, and I think you're getting at this as well. There's a difference between history and law school history. And I was just listening to the oral arguments, which anyone can find, for instance, at C-SPAN's website, the oral arguments in the affirmative action case. I was listening to the plaintiff's attorney. He's doing law school history. What is law school history, Eric Foner?
I'm not a law professor. I'm not a lawyer. Some of my friends are lawyers. But law school history is where the history goes from case to case to case. There's this decision, then there's that decision, and there's that decision, and that's how history goes along. It's decontextualized in terms of what's going on in the larger society. One of my favorite quotes about Reconstruction comes from Elizabeth Cady Stanton, the great feminist. In her autobiography later on, she said, during Reconstruction, the basic principles of liberty, of citizenship, of rights were debated in the halls of Congress, in the, legal judicial chambers, and in every fireside. That's what I love about it, the quote. Every fireside, people are debating these basic principles. And you cannot reduce that to just one case and another case and another case. You've got to get out into the society if you want to know what people were thinking in the early days after the end of slavery and the end of the Civil War. But law school history, and again, I'm not, there are plenty of good lawyers who have done good work, but if you want to see law school history at its best, look at Justice Ketanji Brown Jackson's dissent, in which she really goes after Justice Thomas and vice versa. He doesn't mince words about her. She gives you an actual history lesson, not just analyzing laws and cases and that kind of thing.
Cameron Norris was the attorney for Students for Fair Admissions, which had sued to get rid of Harvard's affirmative action policy. He said, the best source I've ever read on this is the United States brief on re-argument in Brown.
It painstakingly details the legislative history and how the framers of the 14th Amendment saw it as a ban on all racial classifications.
Well,
That's ridiculous.
Yeah, it's ridiculous.
That's totally ridiculous. Yes, of course, they wanted to get rid of discriminatory legislation against black people. But that is not the right way to think about their purposes. And even more to the point, as I said before, people's ideas were changing as time went on. Most Republicans in Congress in 1865 opposed immediate black suffrage. 2 years later, they implemented immediate black suffrage. Most of the people who supported the 14th Amendment when it was ratified said, or at least a lot of them, this will not affect private discrimination. It's really about public policy by governments. A few years later, 1875, many of the same people vote for the Civil Rights Act of 1875, which does exactly what they said they weren't going to do. It bans racial discrimination on the part of public accommodations, businesses. It's not government, it's private discrimination. How did we get from 1866 to 1875? History happened. People saw the discriminations that were being developed against the rights of African Americans. They saw the violence that was endemic in the South in Reconstruction, and they changed their minds. The law school history doesn't give you much of an insight into that.
One more point about the 14th Amendment and the Civil Rights Act of 1866 before I move on to some broader related issues about the race-neutral or colorblind language. Sure, I mean, the letter of these amendments and some of these laws doesn't mention black or race, right? Maybe that was the goal, as you said. I mean, that was supposed to be the goal, but that wasn't the reality of what they were doing there as far as remediation. So Thomas, in his concurring opinion, he says that on January 29th, 1866, Senator Lyman Trumbull, the bill's principal sponsor in the Senate, talking about the Civil Rights Act of '66, proposed text stating that all persons of African descent born in the United States are hereby declared to be citizens. But then the following day, he revised that proposal, removing the reference to African descent and declaring more broadly that all persons born in the U.S., all persons rather than just African Americans. But I don't interpret the significance of that change the same way Clarence Thomas does. So I guess this is another case of law school history.
Yeah, yes, Trumbull did change the language. That is true. But part of the reason was there were a lot of people in this country who were neither black nor white. They were Asian, they were Native American, they were other people. There were even gypsies, it's not a term you like to use now, but that's what they called them then, who would become citizens or their children born in the United States. Trumbull wanted to cast as broad a net as possible to open the door to American citizenship. And the language was broader than just adding Africans to the list of people who could become citizens. But, in the Civil Rights Act of 1866, that law itself uses racial language. It lists all these rights that citizens are going to have, the right to go to court, the right to own property, the right to sue and be sued, and all these things. And it says all citizens are to enjoy these rights the same as white people. An amazing phrase. In other words, white people were now the norm that others would have to live up to. It wasn't colorblind. It was looking at actually the benefits that white people were given in this country and saying, we have to make sure that non-whites are treated the same and are getting the same rights. But they used race as the prism through which to look at the rights of citizens.
Justice Kavanaugh actually brought up something like that or close to that in those oral arguments, and it actually gave the attorney a little bit of trouble trying to answer it.
So today, a benefit to descendants of slaves would not be race-based, correct?
I think that's incorrect, Justice Kavanaugh.
Well, how does that, you just said benefit to former slaves was not race-based in the Freedmen's Bureau. How is that different now?
Well, the remedial exception that this court has recognized is fairly narrow. It has to be prior.
The question is whether it's race-based. You said, I think, to Justice Gorsuch, I'm sorry to interrupt his question, but you said to Justice Gorsuch, I think, that the benefit for former slaves was not race-based. That's correct. Then the benefit for descendants of former slaves is also not race-based. You can make other arguments if you want about that, but it does not seem to be race-based under what you said to Justice Gorsuch, correct?
Not correct. I think there's a difference between the former slaves themselves getting a benefit versus generations later. I think that's a classification on the basis of ancestry, which is still problematic under this court's precedents.
So, Eric Foner, I think what all this brings up, it raises a very old question in our country, and that's one that not only black people are asking about today, but women, gay people. Where should civil rights be protected? In the courts or in legislation, by lawsuit or by legislation? Although there's, of course, overlap here because the court can strike down federal legislation, right? Mm-hmm. Or I guess in the case of Dred Scott, that was Congress invalidating a Supreme Court opinion. We saw this play out in the late 19th century where the Civil Rights Act of 1875 was then struck down in 1883 by the Supreme Court. I mean, what's your take on that?
I will borrow a phrase from Alexis de Tocqueville, always good to quote. He talked about democracy. It should be a habit of the heart. if people take seriously, all people, the notion of citizens' rights, of liberty, of equality in this country, well, you're not going to need court decisions. You're not going to need constitutional amendments. But we haven't reached that spot yet, and indeed we seem to be retreating from it. The 14th Amendment was an effort to make equality a habit of the heart of the American people. It was an amazing transformation of a constitution that had, guaranteed slavery until a few years before this. I think that's where the fight has to take place, in people's hearts. Obviously that's political as well, but we are getting into the, middle almost of the 21st century, and we still haven't resolved this question of what are the rights of citizens and who will enforce them. But one thing we know from reading the text of the 13th, 14th, and 15th Amendments is they put in a final clause in each one saying Congress shall have the power to enforce this amendment. Congress, not the courts, not the Supreme Court. No, Congress. They wanted Congress to have a hold on this, and they didn't trust the Supreme Court, just as now. But now the Supreme Court has usurped the power to define the meaning of the 14th Amendment. That itself is an anti-originalist maneuver, because originally they wanted the Congress to be the ones who protected the rights of citizens. The National Congress, not the states. They wanted to take this away from the states. Before the Civil War, the rights of citizens were defined state by state by state. That's not a national government's principle of, you move from one state to another and suddenly your rights are taken away as a citizen. They wanted to have a national uniform set of principles. And that is a much more important notion than colorblindness.
Yeah, I'm not a constitutional attorney, but there's really nothing in the document about the Supreme Court being supreme over the legislature.
At that time, if you want to go back to originalism, nobody cared what the Supreme Court said. The Supreme Court had completely discredited itself in the eyes of the victorious North through the Dred Scott decision. Northerners, everybody, I'm not talking about radical Republicans, abolitionists. Abraham Lincoln, as much of a constitutionalist as you can imagine, said, this is not a real decision. We do not have to abide. He said, we don't have to abide by this decision of the Dred Scott decision. It's so wrong that we should just ignore it.
Yeah.
That's a pretty radical statement by a guy like Lincoln, who's pretty moderate, Nobody thought that the Supreme Court should determine what the basic rights of American citizens were.
I'd like to see an attorney at some point in these Supreme Court arguments stand up there instead of citing case law, which of course is what they're supposed to do. They're before the Supreme Court. Hold up a history book. I have one in my hands right here.
Oh, good. That's a good one.
Yeah, written by one Eric Foner, Reconstruction, America's Unfinished Revolution.
Let me interrupt you for one point. Yeah. I'm sorry.
No,
but
go ahead.
Once I get going on this, I can't stop. But in a previous case, Justice Sotomayor became the first justice in history to cite Du Bois's great book, The Souls of Black Folk.
Oh, great.
I was at a meeting and she was there, and I asked her, I said, why did you cite Souls of Black Folk? Because that's not a legal document. It's not a law. It's not a court decision. It's not a legal treatise. Why did you cite that in a case? She said, because justices need to know how the world really works.
Exactly. You said earlier there's no black voices available in the halls of Congress in 1866. These things. So, well, you say here on page 258, in establishing the primacy of a national citizenship whose common rights the states could not abridge, Republicans carried forward the state-building process born of the Civil War. It is a singular fact, Wendell Phillips declared as Congress deliberated, that unlike all other nations, this nation has yet a question as to what makes or constitutes a citizen. And you go on to say something that I made a note to include in our conversation here. The 14th Amendment can only be understood as a whole, for while respecting federalism, or what some people call state rights, it intervened directly in Southern politics, seeking to conjure into being a new political leadership that would respect the principle of equality before the law. In other words, there's more to this than, dry readings of case law. It's about what kind of country do we want to have?
You are completely right about that. And that's what's so amazing about the Reconstruction period. This is a very unusual thing in history of people debating what kind of country they want to be. Normally, politics revolves around very specific, issues, but not this general abstraction. But this was because of the destruction of slavery. The abolition of slavery thrust this onto the political agenda. What does it mean to be a free person? What are the rights that these former slaves, what are they going to have? This is the question of colorblindness, and it has nothing to do with it. It's the concept of what the nation is, and we still haven't lived up in a way to that Reconstruction principle.
Something that irks me about all of this, in addition to the notion that I share anyway, that originalism is more of a fantasy than a real judicial philosophy, is that no one ever doubts that the Constitution protects the rights of the majority. It's when we get into an expansive reading of the 14th Amendment, what is often called substantive due process, or what Clarence Thomas derisively calls the rights revolution. That's when we always seem to run into a problem. Who gets to take a seat at the table of the great American barbecue? No one ever questions the majority's rights to these things, but when it comes to, well, we're talking about the Reconstruction period blacks, or today, abortion and women with Roe versus Wade being overturned. You get what I'm saying here.
Oh, exactly. And affirmative action, whether you support it or don't support it, fits into this debate because there are a lot of persons in the majority who benefit from special favoritism in college admissions. Most notably, at the moment, people are talking about legacy admissions, people whose parents went to the college or gave money to the college. But there are many others. I was a beneficiary of affirmative action when I went to college, because I went to Columbia College, which was all male. I did not have to compete with women to get into that excellent college. And by the way, black people were also excluded. There was one black guy in my class. That was not official policy. It's just the way it happened to work out. So the majority, the white male majority, didn't have to worry about somebody taking their place away because other groups simply weren't allowed in to begin with. Clarence Thomas, he argues strongly that people who are beneficiaries of affirmative action sort of feel they don't really belong. They don't deserve to be where they are. I didn't feel that, and frankly, most white people don't feel that. If they get an advantage, they say, hey, cool, great, I'm in now. I just got into Columbia College. I never said, gee, I wonder what would have happened if I'd had to compete with smart women, No, that doesn't occur to us because when you're the majority, you just take the whole system for granted.
Final issue to ask you to comment on here is something that I see happening now when it comes to, well, voting rights, although, voter turnout actually is very, very strong despite some concerns about what the states...
Yeah, it was, definitely.
What the states are doing. But when it comes to voting rights, abortion, other issues, it's like we're devolving back to that earlier period where your rights depend on which state you happen to be living in or standing in at any one time, when the whole point of our second founding was to create a nation. And I feel like the bonds of our republic are fraying for this and other reasons, not to get too pessimistic here, but...
Unfortunately, there's a lot of evidence to support what you just said, unfortunate as is. But, go back to, David Blight's great biography of Frederick Douglass. In that book, he quotes Douglass in the 1890s. This is beyond Reconstruction, but still during the so-called retreat from Reconstruction, in which Douglass said, principles that we thought were firmly established have been boldly challenged and overthrown. That was the 1890s, but that's today also. Principles we took for granted have been boldly overthrown. And this is not the end. There's plenty of other principles that the six-person majority on the court would like to go and overturn. So in the next few years, we got to get ready for this.
I need to read David Blight's book. I saw it actually in the bookshop at the National Portrait Gallery this past weekend. I was there looking at a new exhibit about the War of 1898, and I also checked out the exhibit on Frederick Douglass there, which is really great.
Good.
All people should read, as I mentioned, Eric Foner's Reconstruction. I said that would be my last question, but really quickly here, Eric, when you wrote this book in 1988, did you expect it was going to hold? I mean, everyone cites this as like the book to read about Reconstruction.
Generally, this book took me 10 years to write. Most of that time, I was just anxious to be finished with it. I wasn't thinking about whether it would be the standard work 10 years from now or 20 years from now. I'm very gratified by the response that it has received over the years. But, you know, no book is definitive, so to speak. In the writing of history, being overturned by younger historians or being challenged is part of the game. So I expect other younger scholars to come up with new books on Reconstruction, and I welcome that, and I'm anxious to see the new insights that they may develop. But the fact that this book has so far maintained its position, not as the final word, but as the current word on Reconstruction, is very gratifying to me.
All 700 pages or so.
Right.
Eric Foner, we are indebted. You are always welcome here. On the next episode of History as It Happens, we're coming up on the 70th anniversary of the Korean War Armistice. What has changed? What has stayed the same? Is there any hope for the unification of the Korean Peninsula? That's next as we report History as It Happens, a podcast from the Washington Times.